village applicant here?
Okay.
No, I said I didn't see him in the crowd. Okay.
All right, so moving on to,
Just for your benefit, we're under no time frame here, it was just their initial presentation of a sketch plan, so there is no downside to just postponing that to a future date.
thanks, Eric.
I'd like to hand this one to our planning commission.
I agree, it'd be a nice prime one for them to start reviewing.
It's a very big project. Do we have a slide for the public to see what this thing is?
Probably not around Michelle.
Don't we?
We do, but let's, when they present, if it's all right.
Warm them up, cause this is a monster.
Yeah. New business B and C, both those are for holding, zoning hearing board applications. We have looked at these before, so Eric.
So the first one is, the Davis application for 1640 Farmington Ave. This is an amendment of a prior application, if you recall. This was individuals who wanted to have a home occupation, and they had porta potties stored as well as equipment for delivery in their backyard. You previously voted to oppose this application, and they're now coming in for an amendment. The amendment is to actually build a pole building in their rear yard, presumably to house that home occupation. So I don't know if that changes your prior vote, or what I would suggest is doing another vote this evening, whether you still oppose that home occupation or not.
That said, so it's referred to the zoning hearing board with what we did last time as opposing that. Without objection, are we gonna keep the same thing?
Okay,
So the choice is, so before you voted to oppose it, and we were gonna send a letter and appear. I think we do have to appear anyway because it started out as an enforcement notice. So I believe, unless, I have to talk to the solicitor, unless this changed and took it out of that, however, they still check the box of appealing the zoning officer's determination. So I believe we still have to show up. So we will be there. The question is, are we there just to support the zoning officer, or do you actually actively oppose that home occupation use, which you did previously?
I say we actively oppose this. You guys may not remember, I sent you a picture of that. That backyard's the size of this room here. I don't know how you put a pole building there, but the answer is no.
I agree.
And I'll resend the picture if you guys want. I'm sure I got it somewhere.
Okay, we'll go ahead and vote that one, objection, please.
So the motion would be, I think I heard two agrees, so can we, Don, do you
Don
want
made the motion.
Don, make it as a motion?
I just wanna be more clear on that. What's the difference if
So
we
the
just
only-
go to
the
support the
only-
zoning?
Yeah, so if we, typically you would either be neutral, which means we don't do anything, or you send something to support the application, where we either show up or send a letter saying you support the application, which we've done in the past as well. I think did we do have the doggy daycare? We may have, I don't remember.
Yeah, the doggy
Yeah, I
daycare.
think we did. In this situation, you actually voted to oppose it, which means you did not want the porta potty, use in the middle of your residential zone. And then you didn't consider it a home occupation.
Mhm.
So really, we would be there to actively oppose that application.
Okay.
Okay.
Don, was that a motion?
I'm a motion
And
to
second,
oppose.
that was a second, okay.
Further discussion? All in favor, say aye. Aye. Against? Motion carries.
The next one is more your run-of-the-mill, it's just a setback variance, nothing really stands out on that one, so, we would just
You recommend
recommend from our
referral?
end to just stay neutral and just sending it to the zoning hearing board. Yes.
All- Without objection, we'll send it to zoning hearing board.
Mhm.
Okay, it goes. Thank you.
Great.
New business D, this is Eric was able to work this with the developer over in Sprogel's Run to get those folks, street plowed, because we've not accepted that yet, so Eric, you wanna talk to that real quick?
Yeah, so this is a homeowners association which is kind of caught up with a developer who can't finish the project because his DEP permit expired. It's our understanding that the DEP DEP was on the brink of approving a consent approval as to how that project was to be finished. My fear was, well, I'll back up a second. Those residents were complaining because while they paid taxes to the township, we weren't supplying any road improvements and or plowing of their roads. And I cautioned the township, I didn't want that to happen, because the law is if you start taking care of those roads, there's an argument that you've now accepted them for dedication. So they're not finished, we didn't wanna risk accepting them for dedication, so we came up with this agreement where the township would plow the roads and the developers agreeing not to consider that as dedication, but it allows us to help those homeowners out, while we're kind of stuck in this, fight with DEP.
Okay.
Subletter, so the developer's paying us
Correct.
as a subletter.
Yes.
Is there a motion?
I'll make that motion.
Is there a motion or a second?
Second.
A second, further discussion?
Kevin, how did it go over there plowing the first time?
Oh, yeah.
There's spots that we do not plow over there, is that correct, like the tight parking lot there?
Yeah, there's 2 satellite lots that, the homeowners association is responsible for cleaning up. Manholes are raised, but we have them marked out, and it's not an issue.
Yeah, that's the only obstacle,
Yeah.
right? Whether about 2 inches up?
Yeah, they're 2 inches up, takes a little longer, but it's not a problem.
And for the board and the public's benefit too, it's the other thing we wrote into this is that the developer won't hold it against us if we would damage something like that. It would still be on the developer to come back and fix it as part of the regular development. So don't go out and intentionally do it,
No.
but I'm saying, the agreement protects you as well.
Yeah.
It's tough with a raise like that.
Yeah, agreed. So that was our concern, is we didn't want the developer to come back later and now blame us for problems with curbing, and chip on a curb or a broken curb, and say, now we gotta fix it before they dedicate. So we erase that risk as well.
Okay, any further? And, Don, you done, so make sure we have
It
this.
was first,
Mm-hmm.
second.
Second.
All in favor, say aye.
Aye.
Motion carries. And those folks have been really appreciative on this. They made a good argument. We're paying taxes, so you guys can't get over there and do that. And we took some time to work that thing out, so that's really good. Thanks, Eric. Okay, new business, item E. Eric, this is about the fund accounting as we move towards.
So we have a sewer account right now with really no reason to have it. There's no more money coming into it, so we're closing that out, putting the, existing sewer funds in your capital improvements fund. The other concern I have is that there is a potential for future funds to come into that sewer account, but it's only from properties that we've previously liened. So there'd be money that would have been owed to you before you sold the sewer project. There are liens out there, we won't get paid on those until property sells. But we also wanna make sure those funds, if and when they come in, go to the general account. So that's really kind of what you're voting on, is close sewer account, move that to capital improvements fund, but then any future funds that would come in for sewer will go into your general fund. That's it, everything in a nutshell.
What's the total number in the account? I have no idea.
I think it's around 26,000.
Yeah, I was gonna guess somewhere to
Capital
20, 30,
usually,
but I would
capital
guess
improvements are, sewer or the capital improvement?
Oh, the sewer is
The sewer
26,000.
getting moved over, yeah.
I don't know, I didn't know earlier.
Sorry, I'm winging it a little, cause Michelle would normally do this and have those answers for you, so.
Eric,
Yes.
would we, being that the budget was passed, would we need a budget amendment to add that?
I don't think so, but I can look into that.
Can you look
Sure.
into that to make sure everything is,
So
Okay.
current balance is 73. All right,
In the sewer fund?
yes. And 46 or so in the capital improvement. All right, did we take that one now? What we got on that?
I think I just explained it, so you didn't have a vote at all.
Okay, so we had a motion on that?
No, I don't think you did. You're asking for a motion.
what is the motion? Did we-
Motion on new business E, just so Eric explained on the funds.
What is the official motion?
To close the sewer fund, move those funds to capital improvement, and then allocate any future funds coming in the sewer to go to your general fund,
Can we add pending a budget amendment
if needed.
if needed? Okay,
Okay, get a motion?
I'll make that motion.
Got a motion, is there a second?
I will second.
A second. Further discussion? All in favor say aye.
Aye.
Against? Motion carries.
Trace, point of order, we're done with the agenda, am I correct?
We're done with new business.
New business. All right, before public comment, I may have been zoning out when you said this, but we want to at least discuss that appeal that we, recently. That we
You talking about
recently
the
won.
development for Artisan?
Yeah, that's pretty, important to some people in this room. Did we discuss that, or did I miss it?
Did you want to highlight that one?
I just
Yeah,
want,
so we had 3 different court cases out with our team, as you guys know, and one was an appellant one with the zoning hearing board, went to common pleas court, another one bounced it around, they're acting in common pleas and in commonwealth. And we did get another motion on the judge, back from common pleas, so Eric?
Yeah, so in, the one Artisan case, was a zoning appeal, that, the township won in front of the zoning hearing board. The developer then appealed it to the Court of Common Pleas. The Court of Common Pleas overturned it, so which meant Artisan could develop Phase 2B, under the, age qualified district. The township appealed that to the Commonwealth Court, and asked for a decision from the Court of Common Pleas, which it took, a couple years, I think, to obtain, even though the Commonwealth Court said within 60 days or 30 days or something like that. We received the decision back from the Commonwealth Court, which reversed the Court of Common Pleas, thereby reinstating the zoning hearing board's denial of the developer's claim, but then also asked the Court of Common Pleas whether what their holding was on the variance claim. So at that point, the Court of Common Pleas had to issue a decision on the variance claim. We just received that they denied the variance claim. So where we're sitting right now is the zoning hearing board's determination to deny Artisan's right to appeal Phase 2B as age qualified is terminated. However, arguably they would have a right to appeal the Court of Common Pleas variance determination, but that's unlikely at best, given the fact that both the zoning hearing board and the Court of Common Pleas have now stated that they presented no evidence on the variance claim. So it's beyond likely if they'd be able to win that at the Commonwealth Court. So in that one case, it's multiple issues, and very confusing because we were in a fight between 2 courts basically saying they're not doing what they're supposed to do. But at this point, the zoning hearing board has been completely upheld, and they cannot develop Phase 2B under the zoning. Just to give you a status on the other ones as well, the zoning hearing board heard Artisan's claim for validity challenge, because we told them they couldn't develop either 2A or 2B under the age qualified. They appealed that to the zoning hearing board. The zoning hearing board denied that challenge, and Artisan did not appeal that one. So that one is finalized. That one's done in the township's favor. The township also denied their land development plans to develop Phase 2A and 2B under age qualified. Our arguments there was essentially the same thing as we did for Upland Square tonight, is we asked them for an extension because they had not satisfied our review letters. They refused to grant it to us, which meant we had to take action in August of 2022, I believe. Since they did not grant us an extension and they had not satisfied our review letters, the township denied both of those land development applications. Artisan then appealed. Since 2022, Artisan has now filed their brief The township has filed our brief, and we're just waiting for a court to either have oral argument or to render a decision on that one. So all the work's done on that one, we're really just waiting for the court to schedule oral argument or to, just decide the case. The last remaining piece is the eminent domain case, and in that one, because of all these appeals, Artisan basically said the township's opposition to their development has stalled them to such a point that, we essentially condemned their property from any reasonable use. The court has stayed that case pending all the other cases, and essentially Artisan has to win one of those cases to actually prove their eminent domain. So far, they've lost 2 of 3, and we're just waiting for the last one. So if they lose the third one, the eminent domain case will go away as well, because you've done everything proper. If you've done everything proper, there is no taking of their property. So we're really just kind of waiting on the cards to fall at this point on the land development case, but that's the only one that's really pending right now.
So the last judicial action was good.
Yes, the long-winded way of saying that the good news that we just received was a two-parter in that the Commonwealth Court upheld the zoning hearing board, and then the Common Pleas Court did the same thing in the zoning appeal.
Well, I'm sure everybody followed to the T what you just said. I heard that 25 times and I'm just starting to understand it, but I have to credit Trace with sticking to his guns on this one. You know, from the day we ran, we said we would fight this, and we did, and I know you got some heat for not settling, but, Tracy did a good job. When I didn't understand it, you explained it to me the best we could. But to the public, folks, this is what winning looks like. It cost a lot of money for what he just said. I was just trying to figure out my bills list here. I think it was 86,000 for one of them. But, you know, sometimes you can't measure things in dollars. Those people down in Summer Grove and that whole area, you know, we've got, you know, it doesn't matter the dollars, it matters the results. And Trace, again, I know you took some heat for that, and I appreciate your leadership on that, because I was lost on it a few times. Thank you.
Okay, Don, that answered your question, good to go. We will move on to public comment.